Before we explain what the UN Special Rapporteur does, we should explain the international context for monitoring human rights. There are three main human rights functions that the interstate system has developed over the decades. One, human rights standard setting, in other words, the adoption of international standards in the form of declarations and treaties on human rights. Two, the monitoring of human rights. And three, technical cooperation at national level to build institutions and processes for the achievement of human rights. In the case of indigenous peoples' rights, international human rights standard setting has been accomplished until now through primarily the UN Declaration on the Rights of Indigenous Peoples, as well as International Labour Organization Convention 169 on Indigenous and Tribal Peoples. And we should add at the regional level, the American Declaration on the Rights of Indigenous Peoples. Monitoring of human rights is the function given by states to the UN and other intergovernmental organizations to receive allegations of human rights violations, expose negative and outline positive state practices, and advise how they can be improved. This is done by a constant flow of information between civil society and human rights bodies, and between states and human rights bodies, and through public reports of these bodies to the UN General Assembly and to the UN Human Rights Council. In other words, through the international human rights monitoring mechanism, states are under constant international oversight and are prompted to respect their obligations under the international human rights treaties and declarations. The monitoring of the human rights obligations of states to respect, protect, fulfill, and remedy human rights has been mainly done in two ways. One way of monitoring is through the international human rights treaty bodies, each established under a human rights treaty, including the International Covenant on Economic, Social, and Cultural Rights, the International Covenant on Civil and Political Rights, the Convention Against Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention on the Rights of the Child, and the Convention on the Rights of Persons with Disability. It should be noted that the Convention on the Rights of the Child actually contains specific reference to indigenous children in Article 30. The human rights treaty bodies examine periodic reports that states parties to the treaties are obliged to submit. The treaty bodies then adopt conclusions and recommendations to each state, many of which address indigenous people's rights. Under some of the treaties bodies also examine specific cases of alleged violations submitted by individuals or organizations and issue court-like decisions, which, legally speaking, have the force of recommendations to states, but their political prestige is that of decisions. The second way of monitoring the implementation of human rights norms is by the UN Special Rapporteurs, generically called special procedures, of the UN Human Rights Council. Individuals, or more rarely working groups, hold each of these special procedures mandate. They are able to receive allegations of violations of human rights, visit countries, research center broad topics, and report annually to the UN Human Rights Council and the General Assembly. About 50 such special procedures exist. Finally, the Universal Periodic Review, UPR, of the Human Rights Council is a relatively recent addition to the monitoring efforts of the UN, whereby all states undergo a periodic review of their human rights record by states that form part of the Human Rights Council. Here, again, information of civil society is included in the considerations. It should be said that indigenous peoples have for decades been using these international human rights monitoring procedures, much before the adoption of the Declaration on the Rights of Indigenous Peoples or the establishment of the Special Rapporteur on the Rights of Indigenous Peoples. They have done so with some significant results, with positive outcomes for them, such as various cases under the International Covenant on Civil and Political Rights. For example, in a series of Sami cases, some of which are included in your bibliography, the Committee on Civil and Political Rights, Human Rights Committee as we call it, has found in favor of upholding Sami rights to decide their own membership and has recognized certain traditional economic activities as an indispensable part of upholding Sami cultural rights under Article 27 of the International Covenant on Civil and Political Rights. Human rights treaty bodies also adopt various final conclusions and recommendations to states which address concerns brought by indigenous peoples. Moreover, urgent action procedures of the Committee on the Elimination of All Forms of Racial Discrimination have been used by indigenous organizations to prompt urgent action by states. Treaty bodies have also adopted several general comments, in other words, authoritative interpretations of the various articles of each treaty that are of direct relevance to indigenous peoples, such as the Committee Against Racial Discrimination's General Comment 23 on the Rights of Indigenous Peoples, and the General Comment of the Committee on the Rights of the Child on the Indigenous Child. Similarly, several special rapporteurs have intervened with states to protect indigenous people, such as the Special Rapporteur on Human Rights Defenders, the Special Rapporteur on Religious Intolerance, the Special Rapporteur on Violence Against Women, and others. At regional level now, the Inter-American Commission on Human Rights has requested precautionary measures in certain cases. This happened, for example, in 2011 regarding the Rapa Nui Nation, called Easter Island by Chile, when violence erupted there. Precautionary measures were to protect the people from violence by the Chilean army. The Inter-American Commission has also appointed a special rapporteur on indigenous people's rights. The Inter-American Court of Human Rights has found in favor of indigenous people's rights in various cases, including the Aguas Tigni Mayanya communities versus Nicaragua case, the first international court case regarding indigenous people's rights. In this case, the Mayanya community sued the Nicaraguan government for rights to their traditional land and its resources, as the government had granted a logging concession to private interests in Mayanya traditional territory without consulting with the people, and despite their complaints and requests to demarcate their land. In 2001, the court found that the Mayagna had a right as indigenous peoples to their collective land, and in December 2008, the government completed a process of demarcating and titling the land, giving them title to around 73,394 hectares. Similarly, the African Court on Human and People's Rights has found in favor of indigenous people's rights in the Ogiek versus Kenya and other cases. In the Ogiek case, the expulsion of the Ogiek people, a Kenyan hunter-gatherer community, from their ancestral lands in the Mau forest was found to violate several rights. While using existing human rights mechanisms, indigenous peoples found that these were not adequate to address their rights and make a real difference in their lives, and therefore advocated that there should be a special rapporteur specifically devoted to indigenous people's rights, so as to give the visibility, focus, and results needed in order to improve the situation of indigenous peoples. Some issues of indigenous rights were not adequately covered by the international mechanisms before. In particular, the right to land, territories, and resources, self-determination, and more generally, collective rights. States agreed that such a special rapporteur should be established at the United Nations.